Thank you. I was going to not make this speech, but after the last set of questions, I felt like I really should. This is an issue that I have actually been studying for quite some time. As I looked at this issue, I've heard various different approaches that, frankly, didn't work. Some of the things we've even tried here are really questionable. The right of exercising eminent domain against federal lands or to tax federal lands, those are long shots at best. But this is the first time I've found one that I thought actually had some ability to be successful. The problem is that at the time the Western states were formed, Congress had a policy of disposing of the lands through sale or grant. Now, grant came to individual people. Usually it was a land grant that came if somebody agreed to do something. A sale was an outright sale of the property. That historical context led to Utah's Enabling Act. Our Enabling Act is a contract between the federal government and the state of Utah. That contract said, okay, if you do these things, such as the things dealing with polygamy and the things dealing with the railroads and the other things that were specific covenants in the Enabling Act, then the federal government would do certain things. And those certain things included the grant or the sale of the properties that was previously owned by the federal government. Now, this came on the heel of a significant amount of constitutional debate that has occurred on this issue. There's the provision of the Constitution which requires that each state must come in on equal footing. It's found in Article 1 of the United States Constitution. The equal footing doctrine has been litigated, and in the Texas case, I think it's cited as Gibson, has said that the equal footing doctrine doesn't really apply to this particular provision. So I think that Utah would have a difficult time pushing that. There's also the enclave clause in Article 1 that says the federal government agreed to only have certain enclaves, and those certain enclaves would be military bases and seaports and docks and those sorts of things. And so that one may or may not be able to be pushed as a constitutional principle either. But we had a contract for the federal government, and we still always had the hope that that contract would be honored by the federal government until 1976. In 1976, the federal government, in effect, shot across the bow and said, "You know what? Well, we're not going to honor the Enabling Acts any longer." And so, by federal law, chose to do that. The interesting thing is that the federal government does have the right to handle federal lands, but it does not have the power to breach a contract. Specifically, in Article 4 of the Constitution, Congress shall have the power to dispose and make all needful rules and regulations regarding the territory or the property belonging to the United States. That's what they did. They made a contract right under Article 4, Section 3 of the Constitution. Congress entered into a contract with the Enabling Act. And so it appears to me that the only way that we're really going to be able to determine if the states are going to be able to have its contractual rights honored is to bring a legal action against the federal government by declaratory judgment. And that would be for the court to say, "Court, you tell us whether or not the states do have the right to bring this action. And if they do, then the next step in that action would be to actually bring the second action to determine the elements of damages and determine the elements of what those breaches mean." So it's a two-part lawsuit in a way. First part, declaratory judgment. Second part, if it would find that the court says, yes, states do have the right under their enabling acts, then you move forward to the second part. So when I look now at House Bill 148, I see the elements of what I think is the improper approach to be done. And so I encourage your support on House Bill 148. I think it has sound constitutional principles behind it. It is also one that you do have to push because no state has yet pushed an Enabling Act litigation on the Enabling Act legislation. Thank you, Mr. President, for giving me the opportunity to talk a little bit about our Constitution and our relationship with the federal government.